Hello and welcome to the Rogers Brief for May 26th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. Today I'm going to be discussing the report that came out this week from Special Rapporteur, former Governor General David Johnston. Former Governor General Johnston recommended against a public inquiry over the allegations of interference from the Chinese government in Canadian elections. And so I'm going to talk about that. That's been covered a lot this week in the news, but I'm going to talk about it from the perspective of an inquiry and some of the comments the former Governor General had, Special Rapporteur had for with regard to inquiries. Then I'm going to talk about an event that just finished. I watched online the State of the Courts event, which was held in Halifax. The Nova Scotia judiciary held this event, first time ever, and I'll talk about, first of all, why they did it, and then what was said during the event. And then I'm going to discuss, there's some cases that I want to talk about this week. One is just out of Newfoundland. It's a human rights case, mostly notable for the size of the legal bill that the school board that was defending themselves unsuccessfully, their legal bill was revealed. And then three cases out of Nova Scotia that are ongoing. An update on the C.P. Allen stabbing, student involved in that 15-year-old student. The former CEO of the Better Business Bureau of Nova Scotia, sentencing was adjourned. I'll talk about that. And finally, the verdict. There was a verdict issued this week in the Carrie Low sexual assault allegations case. So talk about that. I'll start off. By the way, you might have noticed there's an addition to the bookshelf, and that is the new book, The Post-Atheist 21st Century. I received some copies in the mail. So reading my own book now is a pretty nice thing. So it goes nicely on a shelf. I'll be sending a few out there for others to read. And of course, you can check the links on my social media stuff, and you can find that on Amazon, easily bought. You can either get an ebook or order a paperback, and it'll be in your house in a couple of days' time. So I hope everybody's enjoying reading through that. Enjoying some of the feedback I'm getting. It's been quite positive so far, so I appreciate people who've reached out. Okay, first story. This issue of the Special Rapporteur, which as has been stated, is not a real position. It was a made-up position for this purpose. And David Johnston, who's eminent Canadian, former Governor General, all those things, has recommended that no public inquiry into the allegations of interference from the Beijing government and other potential foreign actors is necessary. And instead, what the former Governor General has suggested that he will hold some public hearings. Well, he gave some reasons why the allegations do not, in his view, merit a public inquiry. The first one was that the public inquiry would not be particularly public, and that is because many of the documents involved originate with CSIS, the Canadian spy agency, and so would be labeled top secret and unavailable to be disclosed in any event. Well, he's read them, so in effect, what he's asking us to do, the public to do, is trust him, David Johnston, that he has read them and has digested them. Not only that he's read them, but he's received a fulsome, set of documents that disclose everything that was known to CSIS. Well, this is not quite accurate in two senses. One is public inquiries deal with secret stuff. That's not unusual. The Moorhouse case was a good example of that. There was, public or secret documents there, top secret things that were dealt with in camera, and everybody had to sign documents and make sure that they weren't going to reveal anything that was done in camera. But at least there was still an adversarial context whereby those documents could be analyzed and questions asked. The other thing is many documents, we were told from other experts, retired public national security experts, is that there's a tendency to over-label documents as being top secret. Now, David Johnston doesn't go into that. The other thing, in addition to holding things in camera and then revealing what can be revealed after the fact, and there's a way, you talk through things and you make sure you vet them to make sure that you're not revealing things inadvertently by language in a report. But for top secret things now, CSIS, when they go to court and they're looking for search warrants, they're looking for, wiretap, try to get wiretaps on people or whatever, they go to court for authorization. There's a lawyer assigned to handle the opposite side of that, sort of a devil's advocate position, who has top secret clearance and can do all those things, who argues in favor of disclosure. And, it's the adversarial context that we're all used to in court situations and leads to the best outcome. So, whether it's the Arar inquiry or others where secret information has been dealt with, I think that could still be done in a public inquiry setting. Second justification from Mr. Johnston was that he, David Johnston, has seen the documents and they were fine. Well, so in other words, the public inquiry would just be duplicative of his efforts. Well, a political question, I guess, in a sense is, well, okay, if he's saying they're fine, wouldn't the government then be happy with an inquiry that supported that conclusion now that they seem to be getting it? Well, maybe not. It also assumes that Mr. Johnston has received all of the information. As we see in the Mass Casualty Commission inquiry and other inquiries, that's not always the case. And it takes sometimes a second set of eyes and adversarial context before you sometimes realize what you're missing. And I'm not sure, it's not clear, certainly from his 50-some page written report, that he's gone to those steps. It really doesn't engender trust, I guess, to have him as well as the person that he has assigned, given, he has these connections to the Trudeau Foundation, knows some of the people involved. There's at least a perception of conflict of interest, if not an actual conflict of interest. So his recommendation that he be the one that does the public hearings doesn't seem quite right. To me, there should be some unaffiliated, perhaps retired justice, or a national security expert that would allow this information to be digested with a more a person that doesn't have any taint of conflict attached to them. It's been critiqued. The decision's been critiqued from all sides politically. I saw an interview. Peter MacKay was interviewed. Tom Mulcair from the NDP, former leader, was interviewed. Former Premier Stephen McNeil interviewed, all of whom suggested that a public inquiry should be held. David Johnston says that he believes the politicians. He says there was communication gaps, but not credibility gaps. Well, that's easy for him to say, more difficult for the public to accept. Also, he didn't, he was part of the Trudeau Foundation, and of course that's a foundation that supports scholarship and all those things, research. But they also received $140,000 in donations from, unknown Chinese donors, and Mr. Johnston didn't even mention that or seem to think it was important. So people are not satisfied with this report. We'll see what happens. Certainly politically, it's going to continue to be a hot button item. The conflict of interest issue. Former Governor Johnston says, well, he was cleared. Well, he was cleared by former Supreme Court Justice Frank Iacobucci, who Mr. Johnston identified as a friend of his, and also by lawyer Sheila Block, who it's been revealed was a big Liberal Party donor and did not donate to any other political parties. So, not great. Raises another issue, a broader issue that nobody really talked about this week, which is Governors General, and Supreme Court justices coming out after these jobs, after these appointments, and then doing other things. Like the Supreme Court justices are now, they're being hired for all kinds of different jobs with, offering opinions. And of course, they've got the Supreme Court of Canada backing, in a sense, with their credibility. To me, Governor General, Supreme Court of Canada justice should be a final job. After you do that, all right, go write a book, do something else, give some speeches, but shouldn't be monetizing that for your own benefit, which is what's happening here. David Johnston was getting, I think, $1,500 a day to do his work. He's going to continue to do work for another many months on this review, inquiry, public hearings, whatever he's going to call them, which are going to satisfy nobody. Okay, so some views on that. Next thing I'll talk about is just this thing I heard now. It was about 45 minutes long. State of the Courts event held by the courts of Nova Scotia. 3 Chief Justices, the Chief Justice of the Court of Appeal, Michael Wood, Chief Justice of the Supreme Court, Deborah Smith, and Provincial Court Chief Judge Pamela Williams, all spoke. Lots of organizations present, the Bar Society, CBA, other law-based organizations. The Justice Minister was there, the Lieutenant Governor was there, although was introduced as the Lieutenant Governor, although Chief Justice Wood got it correct when he was exiting and he called him Lieutenant. Anyway, 20 or 30 judges there in the courtroom. It was broadcast, live streamed. So why do it? First time the courts of Nova Scotia have done this. They identify themselves as the third branch of government, promoting their openness, promoting their independence. So this was and I was listening to the remarks, they were not designed for lawyers, judges, or legally trained individuals. They were designed for the general public. I think this is an effort by the court to show the public, this is what we do, here are the issues we're facing. And, in some respects, they were doing very well. Chief Justice Wood talked about the Court of Appeal, how it's back up to speed after the pandemic. It's looking to sit outside Halifax. Emphasize the independence of the judiciary. They're one judge short at the Court of Appeal right now, looking for the federal government to appoint a Supreme Court of Appeal justice. Next was Chief Justice Deborah Smith from the Supreme Court, talked about COVID as well and how that has helped advance technology within the court system. Thanked many people for helping with that as the pandemic started. Both Chief Justices Wood and Smith gave very positive outlooks for the courts. Provincial Court Chief Judge Pam Williams, not quite as much. She talked about the history of the provincial courts, and the point of her remarks seemed to be, all right, things used to be really simple, and now they're getting more and more complicated. There's charter applications, there's complicated DUI issues, there's treaty right issues, all coming now before the provincial court, and there's not enough judges. Judges are working super long hours, they're getting burnt out, there's well-being issues. And on top of all of that, COVID, where, the Court of Appeal could do virtual hearings and they're just people making submissions. There's not really much examining of witnesses, that sort of thing. Provincial court is not the same. It's 95% of the cases are going through provincial court, and there was a lot of delays because of COVID. I saw this firsthand myself, and it's caused a backlog, which is still out there. So they're looking for more resources, looking for more judges to be appointed, and trying to keep up with the resources being afforded to the Crown Prosecutor's Service, Public Prosecution Service, and legal aid. So those were the remarks from Provincial Court Chief Judge Pamela Williams, who indicates that she is, I don't know if retiring as a judge or certainly stepping down as Chief Judge. That was a controversial reappointment when it happened a few years ago. And so in a few months, we'll have a new Chief Judge of the Provincial Court, it sounds like. All right, so those are the two sort of policy stories that came up this week. Some cases that I want to talk about. I'll kind of get to Nova Scotia in a second. The first one I'll just touch on very briefly is this case out of Newfoundland. And this was very upsetting, but it's a human rights case. Young boy, deaf, has nonverbal, was cerebral palsy, and wasn't getting proper help in school. And so tried to work with the school. Is between pre-primary and I think grade 5 or 6. So it was years. School board spent just under $700,000 in legal fees defending this challenge to the human rights complaint, and they lost. The Human Rights Commission found that they did violate the rights of 12-year-old Carter Churchill. Like I say, he's deaf, nonverbal, cerebral palsy, needed lots of support, of course, and you need to get that through the school system, and he wasn't getting it. His father, Todd Churchill, who did a good thing by, this wasn't just information that was given out. He had to apply Freedom of Information application to get the legal bills revealed. I can imagine what they had to spend on their end. Unbelievable. Like the amount of money that may have been spent in supports for the young boy instead went to legal fees from the school board. So quite something. You think, anyway, and of course they lost. So they had no right anyway to be doing what they were doing. So very troubling stuff out of Newfoundland there in that case. And good for Todd Churchill for bringing it forward. Nova Scotia cases I want to discuss. First, this development in the C.P. Allen stabbing incident from a few months ago. You'll remember, I've talked about this a few times. 15-year-old student was charged with stabbing 2 staff members, I think including the vice principal. Well, the youth made a court appearance on yesterday, but just to adjourn plea again. Not quite clear what's happening there. You'd think this would start to be resolved. It's not unusual to have plea adjournments in cases if the Crown and the defense are working on a resolution of some sort, but with youth you try not to do that if you can at all help it, and this has been adjourned a few times now. That's not the story that came out this week. It was instead a 30-year-old sheriff, a former sheriff now, has been charged with a breach of the publication ban that was issued in this matter. Ali Al-Hindal was the deputy sheriff's name, is the former deputy sheriff's name. Sounds like the allegation is that he put a post on social media naming the 15-year-old student, and as his lawyer Paul Shepard says, it is almost further circulation of such things is almost assured, and so a big problem. And so he's not working as a sheriff anymore, and so we'll see what happens with that charge. People in the justice system really, they do know better. So this was quite an exception from what I understand. All right, so that's that case. We'll be watching for the youth to enter a plea. Didn't get from the news article when the return date might be for his matter on the main allegations. Okay, the next story I want to talk about is another adjournment of, this is an adjournment of sentencing for Peter Moorhouse, who was the CEO and president of the Better Business Bureau, Nova Scotia, 49 years old, charged and has pled guilty to 2 charges of child pornography, one of luring and another of possession of child pornography. He entered guilty pleas in July of 2022. So why not be sentenced yet? Well, there is Supreme Court of Canada is hearing a case, and the case involves, there's a mandatory minimum for the luring offense, and it's a mandatory minimum of 1 year in jail. And so what's happening in this other case that's gone to the Supreme Court of Canada is that the defendant in that case is arguing that the mandatory minimum violates the charter. Now, you've heard probably in the news over the last few years, there have been some mandatory minimums have been struck down, some have not and been upheld. Hard to predict exactly what's going to happen with this one, but what Peter Moorhouse is wanting to do, or his lawyer at least is on his behalf, is wait until that decision comes out and then have a sentencing hearing. Because as you're being sentenced, you get the benefit, if the sentencing regime has changed at any time between when you're charged or when you're sentenced, you get the benefit of whichever sentencing regime is lesser, I guess, in a sense. Less harsh. And so if the mandatory minimum is struck down, I think Peter Moorhouse is going to try to argue against jail time for himself, or at least not a mandatory minimum of 1 year. So we'll see how that goes. His co-accused, there is a co-accused in this case who is not taking that route, is being sentenced on June 8th, which is still, almost a year after Mr. Moorhouse entered his plea. But so we'll see. But that does happen sometimes. Trouble with it is, it's difficult to predict exactly when a decision is going to be issued. Sometimes courts will say, okay, we'll come back on this date to issue, but more often, they will reserve decision and you just don't know when it's going to come out. And it could be weeks, it could be months. And Supreme Court of Canada being as busy as they are, it's very difficult to predict when that decision may be issued. So we'll see. There may be the judge in that case. I don't know who the judge is that's seized with that case, may lose patience if the Supreme Court doesn't come down with a decision in relatively near future. So we'll see. We'll keep an eye on that. All right, last case I want to talk about came out. Sad case. Doesn't appear to be an unfair verdict. And this is the Carrie Low verdict. There's a decision from Judge Jill Hartland, a newly appointed judge. Although I don't see any issues with the decision itself based on what's been reported. Now, Miss Low made the unusual step a couple of years ago of applying to lift the publication ban in her case so that she could speak publicly about it. The reason she wanted to speak publicly was that she alleges that the police didn't do much of an investigation. It sounds like she has a good point there. She has a complaint against the police, which is going to the Police Review Board in July 10th. There was a sexual assault allegation, and the judge, in this case, Judge Hartland, accepts that Miss Low was assaulted by two individuals, but the accused in this case, Brent Julian, the identification evidence wasn't strong enough to convict him. Now, this was an incident from May 18th, 2018. There was a security video from a bar in Dartmouth that showed Miss Low and Mr. Julian, three others, and then Miss Low's told the police that two men confined and raped her at an East Preston trailer. She has only fragments of memory. She had a blood alcohol content of 161, which is double the limit for driving, and she also had MDMA in her system, so may not have had great memories of the night. She alleges that she thought her drink might have been spiked. She had issues with her memory. There was a co-accused who there seemed to be a strong case against. There was DNA found on Miss Low's clothing from this Alexander Thomas, but he was killed. He was killed November of 2021. And Miss Low had described a second assailant as being tattooed with a light shirt on. Mr. Julian was wearing a dark shirt, didn't have the tattoos. So he was found not guilty. And so we don't know who the second person might be. There's some, a T, something that people were calling him T, but hasn't been caught. Complaint against the police is that they didn't investigate properly. They didn't go to the scene. They didn't get DNA that would have been available. They didn't seize her clothing to do testing on it. And so likely to be some wrist slap, at least there. Hopefully some justice for Miss Low under those circumstances. But in the case itself against Mr. Julian, who was the only other person that they could identify in the video, and he hasn't named the other people that were with him, so that's where that sits for now. I don't think the police are going to probably find the other individuals unless somebody starts talking, but the police themselves, for their negligent investigation, are going to have some issues with the Police Review Board in July. So those are all right. So those are some of the cases I was looking at this week. I wanted to make sure I got waited and heard that State of the Courts report this afternoon. Very interested to see the special rapporteur report and read through that. It was, anyway, not very satisfying for me and others, people that are familiar with inquiries, how those can operate under circumstances just like this. So anyway, it's unfortunate that we won't get a public inquiry. At least it doesn't look like we will, unless there's continuing pressure, political pressure, certainly from the NDP, who could hold the government to account on that. So we'll keep an eye. But until something else happens, we'll report back, and we'll see you again next week. Thank you, everyone, for watching. Don't forget to like, subscribe, and share. And if you are looking for something to read, then go to Amazon. You can order Deficits of Trust. That was the mass casualty one. You can order the Post-Atheist 21st Century on Amazon and enjoy a read. Otherwise, thanks for listening. Thanks for watching, and we'll see you next time.